Directorate for Priority Crime Investigation, the DPCI, also known as the Hawks, say that it will send the docket in the perjury case against the Public Protector Advocate Busisiwe Mkhwebane to the National Prosecuting Authority, the NPA, for a decision. Now, the Hawks say that the institution was not aware that Mkhwebane intentionally decided not to respond to them until her media briefing on Tuesday. And addressing the media, Mkhwebane said that she will not be responding to the Hawks for input in the case. In a matter that has become a public spat between the two officers, Mkhwebane says that she is concerned about the Hawks' choice to prioritize a case of perjury against her when there are more serious cases to be pursued. Now, Lieutenant General Godfrey Lebeya is the head of the Hawks and he joins us now. Thanks so much for your time.
Thank you, madam.
So, firstly, the spat, let's talk to the spat as it would seem to be developing between the Hawks and the Office of the Public Protector. Surely that is unwarranted.
It is unwarranted. There should be no spat between the offices, the Hawks and the Office of the Public Protector. I think what should become clear is that it is not between the offices. It is an individual who will be attached to a particular office, not the offices themselves.
So what does that mean? Who are the individuals in this instance, in these two offices, that are responsible for what is becoming an unsavory public debacle?
The offices will be the public protector in her person, because the allegations that the Hawks is pursuing is not against the office as an institution, is against a person who shall have made certain statements which the complainant alleges that it constitute either perjury or defeating the ends of justice. So all what the Hawks is doing is that it is investigating the allegations that has been made. And I think that when these allegations were made, they were also made in public space. So ours is to get the statement from the complainant, which we have done, get statement from witnesses, get all the necessary documents that are required for the purpose of tabling this before the National Prosecuting Authority. So in doing that, we concluded the gathering of those. We had to place this before the prosecuting authority. Once it was placed before the prosecuting authority, they requested that let's hear the other side, which is why we approached the Office of the Public Protector, which is done by a senior officer that is assigned to the case. I think the Public Protector requested that the Office of the National Head do this personally, which we did in writing. And the request was indeed received on the 12th of December 2019. So they have since responded on the 24th to the investigating officer, who obviously was on leave. And then only after the media briefing did we realize that there is in fact an indication that the suspected person is not prepared to give a statement as requested. What will be happening now is that with the letter that we shall have received, we will be taking this, which I think the National Prosecuting Authority have requested, the statement from the investigating officer, to the effect that we have given the suspected person an opportunity to put the side of the story, and that we will be placed before the National Prosecuting Authority today. So we will then wait for the National Prosecuting Authority to make a decision. So that is what we do. The fact that we are prioritizing certain matters, I think that one should first go and read what is actually the mandate of the Hawks. What is actually the Hawks? The Hawks is a directorate within the South African Police Service. One will understand what Section 205 of the Constitution is saying it gives certain powers to members of the South African Police Service, and those members include those who are assigned to the Directorate for Priority Crime Investigation. We believe that we understand our mandate, and obviously we do not want to be debating with people who are suspected. They have got the right to defend themselves, which is precisely what we were asking. Can you provide an exculpatory statement so that when the National Prosecuting Authority make a decision, they have got both sides of the story? To us, the public protector is not an accused person. It is a suspect. Only when the National Prosecuting Authority has made a decision to either prosecute or otherwise can then the title change to become an accused. So as at this stage, the public protector is only alleged to have done what the complainant say. For us, we consider the public protector as innocent.
Well, the Public Protector has, of course, in turn also cited her mandate and some of what the Public Protector Act states in terms of immunity on her part. And she has quoted Section 5.3 of the Public Protectors Act. And it actually reads that neither a member of the Office of the Public Protector nor the Office of the Public Protector shall be liable in respect of anything reflected in any report, finding, point of view or recommendation made or expressed in good faith or submitted to Parliament or made known in terms of this act of the Constitution. So she is saying that she actually is claiming immunity on this particular matter.
Yeah, all what we do is to investigate. I think that particular explanation of immunity is what should come in the exculpatory statement, so that when the National Prosecuting Authority make a decision, they take that into consideration. I do not want to say what the allegations are, whether it is a report or it is what the court shall have expressed itself. So the complainant shall have made a statement. We don't dispute any view of anybody. We don't judge anyone. All what we do is to gather the information and put before the prosecutor for decision. And we will follow on what the National Prosecuting Authority decide.
Well, the Public Protector contends that she is being prejudiced by the Hawks in that she herself, through her office, has sent many cases of a very serious nature to the Hawks, and you are now, in 5 months' time, essentially having decided that you are pursuing this matter of perjury against her, and she feels that you are prejudicing her.
It is unfortunate that we are mixing two things. There are matters that the Public Protector shall have referred to us, and all those matters are receiving attention. It has unfortunately never been brought to our attention at any given stage that matters that are referred to us are not receiving attention. We shall continue to give attention to matters that are referred to us. But with regard to the allegations against the Public Protector in her person, that if there are any prejudices that they find to be actually been imposed on her by the Hawks, there is an existing judge who is specifically appointed to look at those allegations. And I think that is the correct forum, that the Public Protector in a person should have approached that office of the judge. The judge will look at that and make a decision.
So just for an understanding and clarity from a layperson's perspective, when it comes to prioritizing which cases to pursue or not in terms of the list of priorities, how does the Hawks go about deciding?
You know, whenever matters are with us, we consider them as priority. We are dealing with national priority offenses. So matters that are coming to us are actually of critically important that we need to be prioritizing.
So what are national priority offences?
They are listed. I think that if one go and look at the definition that has been made in Section 17A of the South African Police Service Act, you'll see what is defined as a national priority offences. That act will also refer you to Section 16.1. And Section 16.1 will again refer you to Section 16.2, but it's a list of those.
But what are those offences?
And defeating the ends of justice are included in that list.
And what are some of the others?
So you have got various serious organized crime, serious commercial, serious corruption. So it's a variety of those lists. So it's a list. There is also a schedule that has been attached to those lists. So with regard to what can be completed immediately, it differs. The complexity of the cases are not the same. And one cannot say that we are prioritizing. Why do you prioritize my case? I don't think that suspected individuals should dictate which of the cases should receive priority attention.
No, absolutely not.
All of them are receiving priority attention. Some of them are easy to finalize. And in this instance, we should have finalized it last year. But I think, as you shall see, that we wait for certain individuals to provide certain evidence. There were certain investigations that were being conducted.
So this is a case that is easy to finalize, you are saying?
It's easy to finalize.
So what are some of the ones that you're struggling with?
There are other matters that are complicated, which I think that we deal with complicated investigation. As an example, such as the VBS. It's not one individual, it's not one leg. Those are complicated matters that at times you may see that they are taking longer than a single act where one is alleged to have contravened maybe one section of the law. They are not the same.
So in terms of these priority crimes, which is the oldest one sitting on your desk right now?
At this stage, I can't say which is the oldest. You know, some of them would have been postponed at court. There will be challenges and they will be reminded. People will go to the Constitutional Court and the Constitutional Court will make a ruling. Thereafter, it will go to the High Court. We have got cases that have got more than 10 years that are on the roll. So,
give us some examples. You know, which cases are you sitting with that have been there for quite some time?
Yeah, I wouldn't like to be dealing with specific cases, but I think in the public space it is known whenever these matters are going to court, they are being cited that it is the hawks that are dealing with these challenges, individuals that will be challenging the decisions. I think that we have got a case in Limpopo where an individual has been charged with a pattern of racketeering activities. That case has been going to and from the various courts in the Constitutional Court. It has been postponed, and I think until the February this year, we can expect that it shall still be postponed. We have got matters that deal with the land bank. Those matters are older than 10 years, and they
have been ongoing for a long time. What is the difficulty in those cases?
Some of them you have got convictions. Some of them, the conviction were secured, they were challenged. So it goes to the superior courts, and the matters, some of them have to start from scratch. So those are some of the challenges that you see. You shall have obviously noted among the cases that we deal with in the Eastern Cape, the Omotoso as an example. The trial was in the middle and then it has to start from scratch. Again, these things take time. So it's a number of those type of cases. I have indicated in the past that we have got more than 15,000 of these cases. So we might be talking about 3 when we have got 15,000 of these matters. And when you deal with cases relating to high offices, you need those matters to be finalized so that you don't have a cloud hanging over innocent people. You need to finalize this so that decision can be made, and if they decide not to prosecute, you have that disposed of.
Are there any other perjury cases from people in high office that you're currently dealing with?
You shall have noted that there are other matters that shall have been raised in court. What we don't prefer is to be talking about these innocent people ourselves, advancing that, remember, we are investigating so and so.
Yes.
We say that we treat everyone as innocent, as the Constitution requires of us. So for us, we don't initiate to put names forward and say we are investigating 1, 2, 3. It is unfortunate that on this matter, we just want to clarify that we are not prejudicing anyone, and we intend to do what the law expects of us without prejudicing anyone, without favoring anyone, in fact. So that is all what we wanted to explain, that we are not.
But surely, if you are conducting an investigation into a particular matter, it is a matter that was brought before you by a complainant. So why would you therefore not be in a position to tell us which other public office bearers are being investigated for perjury, if any?
No, it is not in our way of doing conducting investigation. Once you put somebody's name, we understand that there is always a perception that will follow an individual. So it will not be us who initiate to put these names in those public space.
But I'm not asking for names. I'm asking whether there are any other cases of perjury.
There are.
How many?
So I think that I need to go and check, but I think of one other that of senior officials, but I don't intend to be putting names in the public
I'm not going to
space.
ask you for names. So how long
Yes.
have you been investigating that particular perjury case?
I think that it may be something like 8 months or so.
So what's the difficulty with that case? Why aren't you able to wrap it up speedily?
Yeah, you are again dealing with a number of people that are involved. The nature of evidence that you need to get, and the interaction with those who must make decisions. From time to time, you will be directed that, but we need to close this gap. So that is what we are doing. They are not easy cases to prove, which is why the complicated nature required specialized skills to unpack those.
So what was so easy about this particular case against Advocate Busisiwe Mkhwebane?
We can't say easy. Because you can see that we have been investigating this from August last year. If it was easy, we should have finalized in August last year. So there are specialized methods of conducting investigation that we had to pursue, which we will not be unpacking. But I think that, as I say, by December, the investigation was already completed. What was needed was to hear the other side, so that when the National Prosecuting Authority make a decision, at least they listen to both sides of the issue.
And there's no political pressure brought to bear in this instance?
There is no political pressure. In fact, since I took office, there has not been any political pressure, and I don't expect any. And I do not want the members of the DPCI to do anything that suggests that they are working, they are being pressurized politically. No. Political pressure for us will not arise, and we will not obviously be pressurized. We understand the law. We have got various advocates who are investigators. Some are managers, some are legal advisors. We have got doctors in the DPCI, so we understand what we are doing. We don't expect any pressure. But you've always
had those capabilities, you've always had those skill sets, and yet there was political pressure and interference.
I can't, those are still under investigation. I think that it is a matter that a conclusion has not yet been released as to whether there were such. It's still under investigation, but I can promise South Africans that we will not succumb to any political pressure. We understand what the law expects of us and that is what we will be doing.
Well, we're going to have to leave it there. Thank you so much for stopping by and speaking there from the Hawks. Lieutenant General Lebeya talking to us about that response to the Public Protector's press briefing on Tuesday. And of course, we will be speaking to the Public Protector spokesperson, Opa Sekhalwe, later on in the show to get their side of the story. Right now, though, it is time for news with Leanne.